Hello everyone, this is PRACHI Sharma working as an intern at LEXIS and Company, and the topic I'm going to discuss today with you all is restitution of conjugal rights. So the restitution of conjugal right basically comprises of two words. First is restitution and the second is conjugal rights. Restitution means restoration of something which has been lost, and conjugal right relates to the marriage or matrimonial relationship between the husband and the wife. If either party to a marriage withdraws from the society of the another without any reasonable cause, then the aggrieved party has the right to file the petition under the court for the restitution of conjugal rights. And the court will also grant the decree if the court sees there is no legal bar in granting such a decree. So, the idea of providing for restitution by a court decree is to preserve the matrimonial tie as far as possible by enabling the court to intervene and enjoining upon the withdrawing party to join the other. Let's talk about the condition which must be satisfied in order to obtain such a decree. So the first condition is the other spouse has withdrawn from the society of the petitioner. Second condition is there is no reasonable excuse for such withdrawal. Our third condition is the court is satisfied as to the truth of the statements made in the petition. And lastly, the fourth condition is no legal grounds exist for refusing such a decree. So these are the conditions which must be satisfied by the petitioner in order to seek the decree of the restitution of the conjugal rights. Now let's talk about the specific provisions dealing with the restitution of conjugal rights and the remedies available under them. So I'm going to tell you the various sections under which a petitioner can seek the decree for the restitution of conjugal rights. In Section 9 of the Hindu Marriage Act, the petitioner can seek the restitution of conjugal rights. In Section 32 and 33 of the Indian Divorce Act, in Section 36 of the Parsis Marriage and Divorce Act, and lastly, under Section 22 of the Special Marriage Act in case of intercaste marriages. So, in order to get the decree of the restitution of conjugal rights, either party has to file for the decree under the above mentioned provisions. Now, let's talk about a case which is Ranjana Kejriwal versus Vinod Kumar Kejriwal. In this case, petitioner wife alleged that the husband was already married and had suppressed the fact from her. The court in this case ruled that the petition for restitution of conjugal rights is not maintainable since there is no legal marriage. So at last, in the above video, I familiarized you guys with the legal provisions of the restitution of the conjugal rights. Now let's talk about a very important feature of it. So the very important feature of the restitution of conjugal right is to be emphasized is that it is a remedy aimed at preserving the marriage, not at disrupting it as in the case of the divorce and the judicial separation. It serves to aid prevention of breakup of marriage, thus it is a means of saving the marriage. So the restitution of conjugal right remedy tries in promoting reconciliation between the parties and maintenance of the matrimonial relationship between them. But the final decision is that of the parties whether they want to obey the decree of the restitution of conjugal rights and to continue with their matrimony or not. So guys, this is the basic meaning of the term restitution of conjugal rights, the condition which need to be satisfied, and that's all for today's video. Thank you so much for watching.